Thank you, Gemma, and thank you to Gemma and to Geraldine for yet another seminar in our autumn programme. It's great to see so many of you joining them, and this is the last one of 2020. We've got one more on the 9th of December, which will be a legal update, so look out in your diary for that. Also, now's a great time if you've got any topics that you'd like us to put into the 2021 programme, put some details on the chat and then we can collate those afterwards. We're starting already to get some ideas together for that. So now is exactly the right time to be doing it. So without further ado, thank you, Gemma, for organising today. And Geraldine, over to you. Thank you.
Thank you very much, Guy and Gemma, and welcome to everybody to this webinar on the very hot topic of adjudication. As is normal for these sessions, I'm going to do a little brief marketing intro on Driver Tret, which is the company I work for, before I then kick off into the main event, so to speak. So Driver Tret work across the engineering and construction industries, and you can see some of the sectors there on the screen in front of you that we get involved in. So utilities, marine and offshore, power, infrastructure jobs are typical examples. We are a market leader in expert, witness, planning, commercial, technical, importantly, dispute avoidance. Now, of course, whilst this session today is on adjudication, my firm hope is that you do manage to negotiate your way out of it. If you don't, of course, we are here to help. We were established in 1978. We are stock market listed with over 500 staff working worldwide. This particular slide shows the offices that we normally work out of, but I guess like an awful lot of people who are on this session today, you are also working from home. All of our offices do have the phone lines and email addresses obviously diverted to the relevant people. Three main parts of the business. On the left, we have Driver Project Services, which is essentially a staff augmentation business. We can provide project managers, QSs, and planners onto live projects on a short, medium, or long-term basis. I work primarily for Driver Tret, and we provide contract advisory services, commercial and contract management, as well as obviously planning, programming and scheduling, and dispute resolution services. The final part of the business is Dialis, and we provide expert witnesses there into litigation and arbitration. That could be an expert in quantum, delay, and we also have a growing technical division as well. And within the technical division, we have architects, engineers, M&E experts, as well as energy and environmental experts as well. A big long list there in terms of how we can help. Obviously, an awful lot of you have heard me reading out some of these in the past. I will just highlight the reviewing of contracts and subcontracts. That is a hugely important part of our business, and equally that will dictate how well or otherwise a particular project does within your business. Of course, I know that you're all going to study the notes after the session today, so I won't go through those on a line-by-line basis. If I manage to get you a little bit interested in this whole subject area, then you might also want to get a copy of our Digest magazine, which comes out twice a year. Pop to our website, email our marketing department, or of course you can scan the QR code and that will take you directly to this particular publication. A little bit about me. Yes, I'm a quantity surveyor and chartered, ex-Balfour Beatty, having worked there for 5 years as a site QS. Also went on and did my law degree and solicitor's exams, and have now worked in construction claims for over 20 years. So what are we going to cover today? Well, of course, it's all about adjudication. A little bit on the history, explaining what adjudication is, looking a little bit at legislation basics, the process, observations and tips, and then I just want to talk very briefly about a couple of recent cases. So, history. Now, I know some of you on the webinar today might remember the right-hand side of this graph in terms of working in construction in 1987. But what this particular graph shows is essentially the increase in construction cases going through the courts over a 13-year period. And it showed a steady rise. And everybody recognised that, quite simply, something had to be done. There were too many construction cases that were going through the courts. In terms of summons served, again, an upward rise can be seen all the way into 1993 on that one. These facts really culminated in the Latham Report, which was produced in 1994. Quite a big tome of a document produced by Sir Michael Latham, looking at procurement and contractual arrangements within the construction industry. Two of his recommendations were: Item 25, an Act of Parliament should be introduced to back the new NEC contract. And interestingly, the second sentence of that says, some specific unfair contract terms should be outlawed. Well, I think some people might think there's a bit of a quandary there, if ever you've read any Z clauses under the NEC contract. Secondly, item 26, adjudication should be the normal method of dispute resolution. And I think that absolutely Sir Michael Latham, and then what happened afterwards, that particular recommendation has been absolutely achieved. So the problems that existed at that point were that courts were quite simply overwhelmed with work. Arbitration and litigation were seen as being far too expensive and also too lengthy. For a case to last over 2 years was not unusual back then. This lack of speedy resolution was causing cash flow problems. And of course, again, many of you will have read Lord Denning's very famous quote about cash flow being the lifeblood of the industry. So the historical context was essentially too many disputes, too long to actually sort out, and too expensive, which is why we ended up with this system, adjudication. So, well, what essentially is adjudication? When in its most simple form, quite simply, it's a statutory right for a party to a construction contract to refer a dispute to adjudication for resolution. A statutory right. So in other words, it comes from an Act of Parliament. Referring the dispute to adjudication for resolution. So in other words, to sort it out. Importantly, you cannot contract out of the right to go to adjudication. You couldn't write a Z clause into an NEC contract that says the parties cannot refer any disputes that arise to adjudication. That clause essentially would be crossed out and replaced with the statutory right to go to adjudication. The third bullet point, that you can go to adjudication at any time. There was certainly a tendency pre-adjudication that the contractor, the employer, if there were disputes, or the subcontractor, they had to wait till the job was finished before actually pressing the button. And that again was seen as a problem. So the fact that you can go to adjudication at any time was seen at the time as a great advantage. Having said that, my experience is that in the majority of instances, people still will wait until the end of the project before going to adjudication. The fourth bullet point there actually is difficult to explain. The bullet point there says that it is binding until finally determined. You will also see it being referred to as temporary finality. Okay, so in other words, if you do go to adjudication and if a decision is issued by the adjudicator, that's it, unless the parties decide to go to arbitration or litigation, depending on what your contract says. Again, in the vast majority of instances, after an adjudication decision has been issued, that tends to actually end the dispute between the parties. They tend not to go anywhere else. Certainly, in my experience, adjudication is commonly used for issues such as valuations. So straightforward, I've put in my application for payment, it's not been paid. Let's go to adjudication to actually release some money. The valuation of variations, and of course, the principle behind those variations, or if it was NEC, compensation events. Extensions of time, which again, under NEC, comes under the umbrella of extensions of time, and final accounts as well. They would be so generally it does tend to be the time and the money issues. You can go to adjudication on a technical issue, but that is quite rare to see that happening. So some basics then. What are the acts of parliament that are in place that you need to know about? Well, we start by going all the way back to 1996, which is a massive 14 years ago. So the Act is dated 1996. And if you actually go onto the internet and look this piece of legislation up, it is a huge piece of legislation. But only a very small part of it is the bit that we're going to look at today. And you can see on the screen in front of you, essentially, we're looking at sections 104 all the way down to 117. So that is the Act of Parliament that is in place. However, the writers of the legislation realised that either the parties to a construction contract would entirely comply with the Act of Parliament, or in certain instances, actually, they wouldn't. And so they needed a safety net. So, in other words, if there were parts of the construction contract that didn't comply with the Act of Parliament, they wanted to have a safety net that would kick in. And that safety net is called the Scheme for Construction Contracts. The England and Wales version here in front of you, 1998. Similar version for Scotland. And you can see that there's 26 sections there. If you were to print this out in sensible A4 fashion, it's less than 30 pages for both the Act and the scheme. So it is a neat piece of legislation. And those two, the pieces of legislation, so the Act of Parliament and the statutory instrument, the scheme or the safety net, they were in play up until 2009. And in 2009, we had a new piece of legislation that came in, the very interestingly titled, okay, it isn't really, Local Democracy, Economic Development and Construction Act. Now you'll see there that it refers to sections 138 to 145. Essentially, it's almost like track changes in Word. You take these sections and you throw them back in to the 1996 Act, but generally you refer to the Housing Grants Construction and Regeneration Act as amended, and that means that you're encompassing the 2009 Act. Because of the changes, that also meant that we needed an updated scheme for construction contracts. That was dated 2011. And again, for the purposes of this session today, there's the extract from the England and Wales version. So we now have essentially 4 bits of legislation to look at. We've got 2 acts and 2 schemes. We're looking at the most recent, but of course you start with the original and then there's the amendments to it. So when does the Act apply then, when we're talking specifically about adjudication? Well, actually, we start with section 108. And 108.1 says, a party to a construction contract has the right to refer a dispute arising under the contract for adjudication under a procedure complying with this section. Now, most people think, Grace, well, of course I've got a construction contract, but actually it's not quite that straightforward. What we have to do is go back to section 104, because that's where the definition of construction contracts is given. Now, a construction contract is A, the carrying out of construction operations, B, the arranging for the carrying out of construction operations, and C, providing labour for construction operations. So even a contract between a subcontractor and a labour agency would fall within the ambit of the Construction Act. Well, okay, so we know what a construction contract is, but do we really know what construction operations are? We have to go for another section within the legislation here. So section 105(1) then gives a definition of a construction operation, and it is a wide definition. Construction, alteration, repair, demolition or dismantling of buildings or structures forming or to form part of the land, permanent or not. So it does include buildings and structures, services, interestingly, internal or external cleaning, and even preparatory works. So section 105(1) looks very, very wide and straightforward. It kind of falls down a little bit though when we get to section 105(2), because we then have some important exclusions. The first two on the board, I think, are pretty straightforward. So drilling for or extraction of oil and natural gas, actually, that's not a construction operation. It's not a construction contract. So therefore, you couldn't use this particular piece of legislation to actually go to adjudication to sort out a dispute. Equally, item B, the extraction of minerals, also falls outside the Act. For me, those two items are pretty straightforward. You do start to scratch your head though with item C. It's easier to start halfway down this particular clause. So it says, where the primary activity of the site, so that's where to start here, where the primary activity of the site is nuclear processing, power generation, water or effluent treatment, that's the first bullet, and the second is chemicals, pharmaceuticals, oil, gas, steel, or food and drink. So we have a list of specific primary activities, and then we have a limited list of excluded actions. So if you are working on a nuclear processing site and you are involved in the assembly, installation, or demolition of plant or machinery, or the erection or demolition of steelwork to support or provide access to plant on one of these projects, then that is an excluded operation. If you are installing a canteen or doing some painting on any of those particular sites, then you fall within the Construction Act. That has certainly been the subject of plenty of case law in terms of, you'd almost call it a hokey cokey, what falls within the Construction Act and what falls outside the Construction Act. There's one particularly interesting case which involved, from memory, Carrington power plant up in Manchester, and the court held there that actually if some of your work was within the Construction Act and some of your work was outside the Construction Act, you can only go to adjudication on the works that are inside the Act, and you can only then use the payment provisions in the same way. So that takes a little bit of working through. Item D, again, when you read this at first, you think it's pretty straightforward. The supply only of materials in relation to a construction contract, that's an excluded operation. Now, again, within the last year, a very interesting case which involved the supply of concrete. This actually went to adjudication and ended up in court as well. And the court decided that the supply of concrete, even where the concrete was being essentially placed straight into the open hole by the supplier of the concrete, that was an excluded operation. in that particular instance. People have wondered since whether, if the concrete supply firm had have also provided pumps and was providing certain additives into the concrete as it was being poured, would that then have formed a construction operation, and would adjudication then have been permitted? Again, there is grey area there to be aware of. The other exclusion I think is important to highlight here, and this is in a statutory sense, is that a residential occupier contract is not one for which you can use the statute. Now, again, another interesting situation. I, like many other people who work in construction, might have dabbled in the past with getting some work done to my own house. And you may or may not have had a contract in that particular case where you are having your extension done. If you chose the JCT minor works contract, that particular form of contract actually has contractual adjudication in there. So if you wanted to exclude adjudication as a form of dispute resolution, then you actually have to strike through those clauses. You can't use statute in terms of adjudication with a residential occupier, but you might have contracted in to adjudication. So you need to take care to decide whether you do want adjudication to solve your disputes on your house extension or not. So that's when the Act does and doesn't apply. What about the dates then? Well, again, remember, we've got the Construction Act 1996 following the Latham Report. Importantly, the 96 Act came into force in May 1998. And then we had lots and lots of discussions about how well it was working and changes and all the rest of it. Those changes were formalised into a document in 2004, and then we had the Construction Act 2009. It came into force in England and Wales in 2011 and in force in Scotland in November 2011. Now, only in the past few months have I dealt with a particular issue surrounding this. And the issue was that the contracts that the party used were actually contracts relating to before the 2009 Construction Act, which then meant that they weren't compliant with the payment provisions, which luckily for the contractor that I was working for resulted in a very nice payment of the outstanding monies rather quickly when we pointed that out. So yes, these are now old pieces of legislation, but the distinction and the dates are still important. So what changes then did the 2009 Act introduce? Section 139 confirmed that oral or verbal contracts are no longer exempt from adjudication. Originally, there was a requirement that it was only for contracts that were in writing. That was changed under the 2009 Act, and essentially you just have to show now that there is a contract between the parties. Section 140 covered errors by adjudicators. Now, I know it sounds unlikely that an adjudicator being paid a very healthy hourly rate would make a mistake, but it does happen. And so Section 140 essentially introduced a slip rule, allowing, once the adjudicator's decision has been issued, that the parties can read that particular decision. And if there are typographical or arithmetic errors within the calculations, the adjudicator can actually correct them, obviously after checking. Section 141 was again a particular issue that was causing lots of consternation within the industry. And that was, who should pay for the party representative costs in an adjudication? Section 141 makes it clear, I will say to a point, that the costs of allocating the costs of adjudication is ineffective. So essentially, the two parties who've decided to lock horns in adjudication, if they decide to take on external representation, then they bear their own costs. This doesn't interfere with the costs of the adjudicator because, of course, it's the adjudicator who decides how their costs are actually apportioned. Sections 142, 143 and 144 looks on the periodic payment process that's outside of today's scope. And then section 145 looks at suspension due to non-payment. Again, that's not something we're going to talk about today. So the process then of adjudication, and I have a very, very nice chart that's hopefully just appeared on the screen in front of you. And in knowing the process is really, really important. Okay, so let's go through this from the left-hand side. How does this particular process start? Well, it starts with one of the parties issuing a notice of adjudication. So let's imagine, for the purposes of this, that we have a contractor-employer dispute. The contractor is going to issue a notice of adjudication to the employer. The employer then has received it, and the contractor can then issue a request to appoint an adjudicator. It could be a named person in the contract. Alternatively, it could be an adjudicator nominating body, such as the ICE or the RICS, and that adjudicator is then appointed. As soon as the adjudicator is appointed, the contractor, in my particular case, then must issue the referral. Now, between the notice of adjudication and the issue of the referral is a maximum of 7 days. If it was issued on the 8th day, then unfortunately the contractor's referral would be invalid, and the only choice then that the contractor would have would be to restart the whole process because they haven't met the requirements of the Construction Act. So the referral is issued by the contractor, and the employer then has the opportunity to issue a response. Now, generally, the starting point is that the employer would have a 7-day period to issue their response, but normally the employer and their representatives would squeal at that point, "We haven't got enough time. We didn't know anything about this dispute." And quite often they would be given 14 days to put together their response. Once the employer's response has been issued, then there is the opportunity for further submissions. Normally the contractor then would issue their reply, and then you've got the opportunity for the employer to issue a rejoinder and the contractor to issue a sur rejoinder. In theory, the adjudicator has to make his decision within 28 days. Now that can be extended. If the adjudicator and the referring party agree, that period of time can be extended for another 14 days, taking from referral to decision to 42 days. Alternatively, it can be extended for as long as the parties agree. And that essentially is the process. Now, I have to say, it's very tempting to think about some scams that people could use. So, for example, if you knew that an important person within the employer's organisation was about to go on holiday for 3 weeks, then you just imagine that maybe the contractor would be tempted to issue the adjudication paperwork just before that person goes on holiday. And that is a very, very common tactic to see. Of course, wouldn't work too well at the moment given the COVID requirements that are in place. So probably the holiday excuse is not one that we see or have seen too often over the past few months. So some key points. You can go to adjudication at any time. Importantly, the adjudicator must be appointed within 7 days. The adjudicator has got this magic 28 days to come to a decision. That can be extended by 14 days or longer, as I've explained. 5, 6, and 7 are also important. It must ensure, so this is the contractor, of course, you do have the Act of Parliament and the scheme. The adjudicator must act impartially. Okay, really important that it's not a brother or a sister of the contractor, or indeed the employer or someone that plays golf or is in a particular club. Okay, because that would cause problems with this impartiality aspect. The adjudicator can take the initiative in ascertaining the facts and the law. Everybody is very aware that a lot of adjudicators have a background as um, being a technical person in terms of architect or engineer, or indeed a surveyor as well. 7, we've talked about this one already. The decision of the adjudicator is binding pending litigation, arbitration, or the agreement of the parties. Now, remember, if your construction contract doesn't meet those requirements, the scheme for construction contracts, remember again, there was a 1998 version and a 2011 version, they fill the gaps if the contract doesn't comply with the Act. Now, crystallisation is certainly a word that if you read through the cases that have gone to court following adjudication, crystallisation does appear regularly. And there has been issues about, well, hang on, this isn't a dispute, so you can't go to adjudication yet. When does a disagreement actually become a dispute? Because if it hasn't crystallised, then quite simply, the adjudicator won't have the authority to make a decision. And there have been several cases about whether the referring party can rely on documents that are being seen for the first time in an adjudication. So, crystallization essentially means that the referring party or the contractor, in my particular scenario, has issued all of the documents on which they are going to rely. Now, over time, that particular issue has become easier. And the courts essentially say that as long as the dispute hasn't changed, then further supporting evidence can be provided. My view, though, of course, is that I would want, if I was working for the referring party, all of the documents to be issued in advance because, of course, essentially what we want to do is negotiate the best settlement possible. And having a rehearsal in advance of an adjudication is always a good idea. Because if the employer wins the crystallization argument, then quite simply, any adjudicator's decision would then not be enforceable. So, what types of adjudication do we see? The ambush adjudication, referring a large, complicated dispute when it's least expected, with a huge number of documents and expert reports. A case I read a couple of weeks ago started off with the sentence, the referring party issued 14 lever arch files to the responding party. And of course, remember, I've said that the employer and their representatives tend to have between 7 and 14 days to respond. 14 lever arch files just seems something that you would want to cry over. But of course, in this COVID environment, that means a heck of a lot of printing. I definitely would not advise the Christmas Eve adjudication. Having a situation where a notice of adjudication is issued, let's say 7 days before the holidays, is not a good idea for anybody. I'm sure the vast majority of people on today's webinar are very used to having their holidays disturbed by questions and queries and issues that come up. And actually, Christmas is the one time of the year when it is very unusual to have your holidays disturbed. And adjudicators also like to have holidays, and they will take a dim view of this particular tactic. What tends to happen is that the adjudicator will put an appropriate amount of pressure on the parties to try and get them to actually extend the period. So actually, all you are doing with the Christmas Eve adjudication is giving the other party more time to put their case together. Okay, it would be a very rare situation where, through a Christmas Eve adjudication, the periods of time remain the same. The kitchen sink adjudication, I've given you an example there of an adjudication with 14 lever arch files that was referred to recently. Yes, we have seen disputes with 100 plus files of evidence. Again, for me, not a good tactic unless everything has been rehearsed in advance. You might require significant experts as well as external assistance, and trying to respond to all the issues in the time allowed might prove very, very difficult. We do also come across, though, the absolute opposite, which is a point of principle adjudication, where there is a very narrow issue to be decided on. I'm thinking possibly under an NEC contract, whether a notice of a compensation event was given in the 8-week time period. Essentially, a point of principle adjudication is there, hopefully, to have a domino effect. So, in other words, whichever way this point of principle goes, it means that it's less likely that you would then have a full blown adjudication on all of the issues. It's aimed at actually resolving future negotiations. I have to say that actually it is rare to see this particular type of adjudication, because the parties think to themselves, well, if we're going to go, we might as well go on the penultimate interim account, or indeed on the final account. One that, in my experience, is extraordinarily popular is the smash and grab adjudication. And quite simply, this is where the contractor, again using my example, could equally be the subcontractor, properly complies with the payment cycles by giving an application for payment, and the other party doesn't do their job. They fail to give a payment notice or interim certificate, or fail to give a pay less notice. It is seen as quick and cheap, with a very high success rate, and indeed the potential for a big payout. However, again, remember, it's only temporarily binding, and then there would be nothing to stop the other party going to adjudication on the next interim certificate. We've talked already about the procedure, the notice, the appointment of the adjudicator, the referral, the responding party's response. We then have the award or the decision. At that point, the vast majority of payments or monies moving from one party to the other, they are actually paid. My view would be it would be at least 99%. Where an adjudication is completed, a decision is issued, and the parties abide by the decision of the adjudicator, essentially to pay monies out. It is rare that you get to step 6, which is enforcement or legal challenges. So, what things should you watch out for in terms of the procedure? Well, definitely get hold of a copy of the Act and the scheme, because this is like a rule book for how the adjudication should run. Within the notice, you have to give the nature, a brief description of the dispute, and the parties involved, where and when the dispute has arisen, what redress is actually sought. So, in other words, are you looking for payment or an extension of time or a particular decision? And then also the names and addresses of the parties to the contract, including, where appropriate, the addresses where the parties have specified for giving notices. Importantly, the notice itself sets the boundaries of the adjudicator's jurisdiction for the adjudication itself. You must get the notice absolutely correct. You must issue it to the correct name of the party. You must issue it to the right address, and you must make sure that the redress you are seeking is clearly set down. What you can't do then in the referral, the response, or the reply is change your argument. Okay, you can't add additional points, otherwise, the other party can then raise jurisdictional challenges. If you're seeking recovery of money, think, do you want the adjudicator to have the authority to award sums both ways? Is it going to be a black and white issue that the adjudicator is going to award the sum of, let's say, £140,567.39, or would you like the adjudicator also to decide or such other sum as the adjudicator decides? Do you actually want the adjudicator to order payment or just to certify the figures? So, the appointment of the adjudicator. Normally, what happens in the morning, the notice is issued, and then in the afternoon, the appointment of the adjudicator happens. Either the parties agree, the adjudicator is named in the contract, or you're using one of the nominating bodies. Once the adjudicator is appointed, they confirm that they're able to act within the relevant timescale. And also within the adjudicator's points, it clearly says, as it does in the Act, that the parties are jointly and severally liable to pay the adjudicator's fees. Now, either party can then consider raising a jurisdictional challenge. Again, in my example, the contractor is taking the adjudication. It's unlikely it's going to be a jurisdictional challenge from the contractor. It's normally the employer who might say something like, no dispute exists, or I've never seen this paperwork before, or this adjudicator is biased. I've seen these guys drinking together in the local pub. Again, the last one is unlikely to happen in the current COVID environment. If you are on the employer's side or receiving an adjudication, essentially you get one shot at these jurisdictional challenges. You need to get them in once you receive the paperwork. Okay, you challenge the jurisdiction, but you must carry on with the adjudication. Otherwise, it's highly likely that the adjudicator's decision will go against you. You will have to pay out, and the only then way you can have that decision overturned is by going to arbitration or litigation. Once the jurisdictional challenge has gone in, the adjudicator then has to decide whether to reserve their position and carry on, whether they can decide their own jurisdiction, to get a declaration from the court on jurisdiction, or to resign. Now, I'm not saying that adjudicators are generally selfish and self-interested, but in my experience, they tend to either reserve their position and carry on, or say that they've got the power to decide their own jurisdiction and they carry on. Items 3 and 4 are very unusual to see, where they go to court or they actually resign. The referral is then issued no later than 7 days after the notice. And again, that's a magic period. If you go for day 8, the whole thing collapses. The referral must contain the full case and the documents and the information. Normally, documents such as a copy of the contract in full, possibly drawings, witness statements, expert statements are all attached. Importantly, you must match the referral with the notice. So if I'm instructed to prepare the adjudication paperwork, I prepare the referral first and then prepare the notice from the referral, not the other way around. So that when I'm issuing the notice, the referral that is there ready to go. Remember, you can't bring in new arguments in the referral. You can't change the redress that you're seeking. And the other thing to remember is that 28 days runs from the date that the adjudicator receives that referral. The response, again, normally it starts off with 7 days. Normally the responding party wants more time. Normally that ends up as 14 days. The responding party is going to say, essentially, oh no, that's not right. The responding party can also bring in counterclaims, which could include items such as liquidated damages or defective work. And the adjudicator will then have to decide whether the adjudicator has jurisdiction to consider those issues. We've talked already about the exchange of some submissions or the pinging between the parties, the adjudicator can also ask for further information. So as the adjudicator perhaps is reading the referral or the response, they can actually write to the parties and say that they would like to be addressed on a particular issue. Again, pre-COVID, meetings were very, very common. Essentially, the adjudicator there is looking to simplify the dispute, clarify any conflicting factual information, testing the submission and the evidence. It will definitely aid the adjudicator's understanding if the parties are able to address the adjudicator. Looking at interviewing witnesses, looking at the expert evidence, and perhaps also visiting the site. Again, in this current COVID environment, actually meetings are very, very rare. The decision then is issued, again, 28 days after the referral. It includes reasons if one of the parties requests it, or indeed if the contract requires it. The adjudicator will apportion their fees. So if the contractor wins in full, then you would imagine that the employer will be told in the decision to pay the adjudicator's fees. But remember, they are jointly and severally liable. So if the employer fails to pay, the adjudicator can sue the contractor for their fees. The contractor then would have to back sue essentially the employer. Remember, we talked about this issue of temporarily binding, and of course, the parties must comply with the decision. Interestingly, the adjudicator does seem to be in a rather privileged position. The adjudicator can get the law wrong, the facts wrong, and arrive at the wrong answer, but the decision would still be enforceable. However, if the adjudicator answers the wrong question, then the decision can be challenged. Regardless, the adjudicator still gets paid, which is rather nice. Remember that it is very unlikely that following an adjudication, you would end up then going to court on enforcement. Even if you did, in the vast majority of cases, the courts will support and enforce adjudicators' awards, even when mistakes are made. So, a couple of observations and tips to be aware of. I've included within the notes reference to some of the different types of adjudication that exist that the RICS themselves have brought in recently. We have the standard adjudication process. There's no limit there on the value or the nature of the dispute. You can see the application fee there at the bottom. Because of COVID, they also introduced summary adjudication for claims below £20,000. The nice thing about this is that the fee is capped at £1,000 plus VAT. Can I definitely draw everybody's attention to this if you are outstanding retention monies? Now, if the retention was under £10,000, actually, I'd probably point you in the direction of the small claims court. But if it's between the £10,000 and the £20,000, summary adjudication is looking like a good possibility. The RICS have also introduced low value dispute adjudication for disputes less than £50,000. Again, you can find all of this on the RICS website. In my experience, these have not been used to a great extent so far. Now, do you remember before we talked about residential occupiers? We said that residential occupiers can actually end up with adjudication because they've used, for example, the JCT minor works form. Alternatively, you might use one of the JCT homeowner occupier forms, and within that form, there is homeowner adjudication as well. So that's another possibility to watch out for, or possibly to embrace as well. Now, in my opinion, the procedure does favour the referring party. Time isn't on the responding party's side. The key for me, if you're the other side, is Get the jurisdictional challenges in at the start, and avoid wherever possible upsetting the adjudicator. And believe me, that does happen. We do see multiple adjudications, and you have to be careful as to whether a particular matter has been adjudicated before. Remember the issue about the fees? It's only the adjudicator's fees that are recoverable, not the party representative costs. There is a reasonable chance, though, as well, of unpredictable awards. I would say 85% of awards are absolutely predictable, but 15% are a little bit off the wall. So that needs to be factored into any decision to go to adjudication. Adjudication is seen as a bit of a quick and dirty process. It is quick, and yes, it is dirty in the sense that you don't get a lot of time to challenge the other party, but it is good for cash flow. It's cheap, certainly, if it's compared to litigation or arbitration. And again, I've put there this temporary finality point. It is generally seen as unsuitable for complex cases, but there is nothing to stop you chopping it into sections. There is scope for ambush, and equally, I can see the temporary finality being a problem. Adjudicators can have an inconsistency of approach, and I'm not happy about the fact that bad decisions are enforceable, but I think you have to take the rough with the smooth on this. I think if somebody said to me, you're only allowed to give somebody one word of advice in relation to adjudication, then quite simply that word would be evidence. Make sure that you put your evidence together very carefully. Make sure you follow the time constraints. Make sure that you understand the adjudicator. Make sure that your documentation is properly and carefully drafted. A key for me is if you were to give your documents to someone outside of the industry, will they be able to understand them? Be mindful of the adjudicator's limitations as well. And again, this jurisdictional challenges must be raised early. Adjudication was invented for a reason. It was there to improve cash flow. So of course the referring party has the advantage. Anticipation, though, from the other side is important. Be prepared, and remember that adjudication can be good, bad, and very ugly. Finally, just a couple of notes on some recent case law. A case back in 2019, Barry M Cosmetics and Merit. Barry M Cosmetics is the employer and Merit is the contractor. Final account went in December 17 and an adjudication in July 2018. The dispute was 1.1 million and they were looking for a 35-week extension of time. The response document included an 800-page delay report. And the reply in response included another delay report. So the parties had already had significant exchanges. The adjudicator then only permitted the employer, in this case, a 12-page rejoinder. Barry Cosmetics lost and then said that this was a breach of natural justice. The decision was upheld. There was no breach of natural justice. A 12-page rejoinder was more than sufficient. Corbuild and Cleaver in 2019. In this particular case, this was all about a wrongful termination issue. In this case, the adjudicator's decision was not upheld. There was a breach of natural justice because there was a failure to consider evidence, and a decision was reached on a ground that was not advanced by the contractor. Broseley and Prime Asset Management. This was a smash and grab type adjudication. In this particular case, Broseley won and Prime claimed a stay waiting a true value adjudication, and the courts quite simply said, you have to pay out. You can't start a true value adjudication until the smash and grab adjudication has been paid out. Now, I can see that we are very, very short of time. The next case I know we are going to go through on the next session anyway, So I'm going to flick through the next couple of slides here because I can see that Gemma is desperate to get back on because she knows that we have some questions. I'm hoping Gemma is, here we go. She's doing the business here on the slides for me. Is a party required to make payment following an adjudicator's decision if they're intending on referring the matter to the courts? So absolutely yes. So what would happen here? Again, take my contractor wins the adjudication and the employer loses. The employer does have to pay out. If the contractor then doesn't receive their money and goes for enforcement proceedings, it's going to be a very high likelihood that the employer will lose on enforcement, will have to pay the costs, will have to pay interest, and of course will have to pay the adjudicator's decision. So it's my view on the figures, Matthew, but of course there's a little bit of guesswork here. 99% of adjudicators' decisions end there and they're paid out. If it goes to court, that 1% that do end up in court, 99% of them are a rubber stamping exercise saying that the adjudicator's decision was right, and then they are paid out. So it is very rare to actually end up with a decision like the Core Build and Cleaver case, where actually the adjudicator's decision was thrown out. I want to say next slide, Gemma, at this point, but obviously I mean next question. Do we have any others? Gemma is reminding everyone, if you do have any questions, this is your last chance to actually put them put them on the screen. We might have another question coming now. We will see. I can see some people typing. I will just do my little Gemma's sound isn't working right. So let me do a little bit of finishing off here. If I can go back to the presentation. Yeah, excellent. So hopefully I can feel Gemma's coming back in now. I'm going to say a big thank you. Oh, hang on. Right, we do have another question. It's okay, Gemma. And I've got another question here from Duncan. So has a rather attractive looking football at the moment, though, Gemma. It says here, right, is it right to say if the claimant is in a terrible financial position and have no method of paying the monies back, then that would mean that the monies could be withheld until the next adjudication? Right, I have got one example of that did happen quite recently. It was a plate of spaghetti between two parties. And when I say a plate of spaghetti, essentially there was interrelationships between, I'm going to say, the employer and the contractor. They were both in an absolutely terrible financial position. And because of the family relationships and the terrible financial position, the courts decided not to enforce the adjudication. Having said that and given that example, my view is that if the claimant is in a terrible financial position because of this job, then actually the courts are more likely to decide that they are going to have that particular amount paid out. They would have to be almost, kind of within a day or two of insolvency for the courts to actually decide the opposite. So yes, that is a possibility, but it's a very, very small possibility in my experience. Quite often, again, if I go back to my employer contractor, the employer quite simply can't show the contractor's terrible financial position because they haven't got access to those papers. So a very unusual position, but yes, it does happen in very, very few circumstances.
Excellent. I think you might have got away with it today, Geraldine. So I don't think we have any more questions in at the moment.
Excellent.
Oh, I've said that and now someone started typing.
I'm going to put my last slide on now with my contact details. So